Chief Justice John Roberts issued a rare rebuke today, hours after President Trump called to impeach a federal judge who tried to block his deportation flights. Roberts did not name the president specifically, but made it clear that calling for impeachments over judicial disagreements is not the way democracy works. President Trump is calling for the impeachment of federal judge James Boasberg, who temporarily blocked deportations of alleged Venezuelan gang members Saturday night. The planes full of migrants did not turn back as the judge ordered.
We removed terrorists. That should be a celebration.
So what just happened, guys? The floor just dropped out from under American democracy. Not metaphorically, not in some abstract slow-motion decline that political scientists will analyze decades from now. I am talking about a single, searing, irreversible moment that exploded across television screens and instantly burned itself into the history books.
That was a bad group of, as I say, hombres.
Judge Boasberg now demanding the Justice Department provide additional information about why Trump officials refused to comply with his order. In response, the president posted, quote, "This radical left lunatic of a judge, a troublemaker and agitator who was sadly appointed by Barack Hussein Obama, was not elected president."
Trump is doing what Trump does, rolling through his speech patterns, feeding off the energy of the crowd, veering wildly off script into territory that makes his handlers flinch. But this time, he is not just attacking the usual targets. He is not just swinging at Democrats or the media or some foreign leader who annoyed him. He is going straight for the judicial branch. He is making claims that his presidential power places him beyond the reach of federal judges, that the courtroom doors are closed to anyone trying to block his agenda, that the Constitution as commonly understood simply does not apply to his decisions about immigration or trade or national security. He is telling the country, in essence, that he is the law.
Hours later, Chief Justice John Roberts issued a rebuke of the sentiment. Without naming the president specifically, Roberts wrote, quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose."
John Roberts, a man who has made a career out of speaking as little as possible about matters of political controversy, issued a statement. Not a leaked comment to a friendly reporter, not a vague remark at a legal conference, a direct, unambiguous public rebuke of the president's behavior. Roberts said, in language that was as pointed as judicial decorum allows, that for more than 2 centuries, impeachment has never been an appropriate response to simple disagreement with a judicial decision. He reminded the country that the appellate process exists precisely for that purpose.
In America, this democracy is over. If they don't, and we go to the Supreme Court and it is defied, democracy is at real risk, and there will have to be extraordinary action taken.
A Supreme Court justice physically removing themselves from the presence of a president who is attacking the Constitution is a visual that no amount of spin can erase. This is the institution of the judiciary standing up, turning its back and saying, "We will not participate in this demolition." Supreme Court justices do not do this. They are trained, disciplined, and socialized to be the most restrained figures in American public life. They avoid controversy. They refuse to comment on pending cases. They maintain a studious distance from the political food fights that consume the other branches. Their power depends on the perception of neutrality, on the idea that they are above the partisan battlefield.
Judges around the country work very hard to get it right, and if they don't, their opinions are subject to criticism. But personally directed hostility is dangerous, and it's got to stop.
That if a president does not like a ruling, his remedy is to appeal, not to attack the judge personally, not to call for their removal, and certainly not to threaten the entire edifice of judicial independence. This is Roberts speaking in code, but the code is not hard to crack. He is essentially telling the president, you are violating the basic norms of constitutional governance, and you need to stop. When the cautious, consensus-building Chief Justice decides he can no longer remain silent, you know the guardrails are being tested to their absolute breaking point.
U.S. District Judge James Boasberg now saying that the government appears to have acted in bad faith. This comes after the hearing wrapped just moments ago to determine whether or not the government violated his court order to stop the deportation flights, 2 of them with alleged members of a gang, to a mega prison in El Salvador.
The source of Trump's specific fury is a federal judge named James Boasberg, a name that has suddenly become a rallying cry and a target. Boasberg is a federal district judge in Washington, D.C., an Obama appointee who has presided over cases challenging the legality of various Trump administration policies. And Trump, in response to rulings he did not like, decided that the appropriate response was not to file an appeal or argue the merits of the law. It was to publicly call Judge Boasberg a lunatic. A lunatic. The President of the United States stood before the nation and used that word to describe a sitting federal judge. And then he went further.
That federal judge is demanding the government explain why it ignored his order blocking the deportations of more than 200 alleged gang members. President Trump posted on social media calling for the judge to be impeached, saying he's radical left lunatic, a troublemaker, and agitator. Now Chief Justice John Roberts is responding.
He demanded Boasberg's impeachment not because Boasberg committed a crime or engaged in corruption, but because Boasberg issued rulings that Trump disagrees with. This is a fundamental misunderstanding, a potentially deliberate misunderstanding of what impeachment is for. Impeachment is the nuclear option, reserved for treason, bribery, high crimes, and misdemeanors. It is not a customer complaint box for disgruntled litigants who lost a case. By calling for the impeachment of a judge whose rulings displeased him, Trump is trying to weaponize the removal power as a tool of political intimidation. He is sending a signal to every other federal judge in the country: rule against me and I will try to have you destroyed. The underlying legal argument that has Trump so agitated is even more concerning than his rhetoric. During these legal battles, Trump and his team have advanced a theory of executive power that is breathtaking in its scope. They are arguing in court filings and public statements that presidential authority in certain domains is essentially absolute. The domains they reference, national security, immigration enforcement, trade policy, are not trivial. They are vast, sprawling areas of governance that touch nearly every aspect of American life. The claim is that when the president acts in these areas, the courts have no business second-guessing him. Judges should step aside. Judicial review, the bedrock principle established in Marbury versus Madison, should simply evaporate because the president says so. There is historical precedent for broad executive discretion, particularly in foreign affairs. But what Trump is proposing goes far beyond discretion. It approaches a kind of legal immunity, a zone of executive action where the Constitution's checks and balances do not operate. This is the argument that made the Supreme Court justice walk out. This is the argument that made John Roberts issue his rare statement. This is not a normal policy disagreement. This is a full-throated assault on the very concept of limited government. And then we have the reported exchange that has legal circles buzzing with a mixture of horror and disbelief. During the proceedings involving Judge Boasberg, there was an extensive back and forth about the limits of judicial authority. At one point, Boasberg reportedly pushed back against the administration's claims of unlimited executive power with words to the effect of, "We do not care. We will do what we want." Now, those words, stripped of context, sound like a judge admitting to lawless behavior. But context is everything here. Boasberg was not declaring that the judiciary is above the law. He was pushing back forcefully and perhaps with some exasperation against the idea that the president can simply declare himself immune from judicial oversight. He was defending the essential, non-negotiable principle that courts exist to check executive power. The statement was a declaration of institutional backbone, not an admission of judicial tyranny. But in the current political climate, absurdly, that important distinction is being obliterated. The administration's supporters are already weaponizing the quote to paint the judiciary as out-of-control activists who openly admit they do not care about limits. But the reality is the exact opposite. The judge was trying to uphold limits, and the president was trying to erase them. The entire political and legal establishment is now holding its breath because the Supreme Court's docket is a ticking time bomb of cases that will force these exact questions to be resolved. Multiple major disputes are winding their way through the appellate pipeline, all of them converging on the same fundamental question: how much power does this president actually have? There are cases challenging the legal basis for the sweeping tariffs Trump imposed using emergency economic powers. The core question is whether the president can unilaterally rewrite American trade policy without meaningful congressional input. There are cases about birthright citizenship where Trump issued executive orders attempting to end the automatic grant of citizenship to children born on American soil to undocumented parents. This directly challenges the plain text of the 14th Amendment, which could not be clearer in its guarantee. There are cases about the mass deportation operations where the administration has been deploying military assets and invoking wartime statutes to remove individuals with minimal due process. All of these cases are careening toward the Supreme Court, and the justices are going to have to decide in ruling after ruling where the limits of the presidency actually fall. Here's the excruciating dilemma facing the conservative majority on the Supreme Court. 6 justices were appointed by Republican presidents. 3 of them, Gorsuch, Kavanaugh, and Barrett, were personally selected by Donald Trump. They are ideologically conservative, and in many cases they likely agree with the policy goals the administration is trying to achieve, but they are also institutionalists. They care about the long-term legitimacy of the court. They know that if they rubber stamp every power grab, they will be remembered as the majority that dismantled the separation of powers. If they side with Trump on every major case, they will confirm the worst suspicions of their critics, that they are not jurists but partisan operatives in robes. If they rule against him, they will face the full fury of the MAGA movement, which will accuse them of being deep state traitors who stabbed their own appointer in the back. John Roberts, in particular, is acutely sensitive to the court's public standing. He has spent years trying to convince the country that the Supreme Court is not just a political body, that its decisions are based on law, not on personal preferences. The attack on Judge Boasberg and the subsequent walkout have made that job exponentially harder. The mask of impartiality is being ripped away by a president who wants the court to be a partisan weapon and by a base that expects total loyalty. The constitutional scholars are not mincing words about the danger we are in. There is a notable article from Stanford that has been circulating widely among academics, and its argument is chilling. It suggests that we are not merely in a constitutional crisis, which implies a singular, acute event that will be resolved. We are in something worse. We are in a state of constitutional rot, a gradual systemic erosion of norms where each new violation makes the next one easier, where the abnormal becomes normal, and where the institutions that should provide resistance gradually lose their will and their power. The argument is that Trump is not just violating isolated rules. He is changing the baseline understanding of what a president is permitted to do. Every time he attacks a judge and faces no consequence, the next attack becomes more likely. Every time he claims that his authority trumps judicial review and his supporters applaud, the expectation of obedience to the courts diminishes. He is teaching a generation of politicians and voters that the Constitution is a suggestion, not a command. And the scariest part of all this is the boomerang effect that will inevitably occur. Trump will not be president forever. Eventually, a Democrat will occupy the Oval Office, and that Democrat will inherit whatever powers Trump has successfully claimed for the executive branch. If Trump establishes that the president can declare an emergency and levy tariffs without Congress, a future Democratic president will use that exact same power to impose carbon taxes or climate mandates. If Trump establishes that the president can ignore judicial orders on deportation, a future president could ignore judicial orders on gun confiscation or healthcare mandates. The sword cuts both ways. Authoritarian powers claimed by one side become permanent tools for the other. And yet, our political discourse is so tribalized, so focused on winning the immediate news cycle that nobody seems to be thinking about the long-term consequences. This is precisely why the walkout and Roberts' statement matter so profoundly. The judiciary is fighting for its survival as a co-equal branch of government. Roberts is not just defending Judge Boasberg because he likes him or because he has some secret policy preference. He is defending the idea that judges must be able to issue unpopular rulings without facing political execution. The justice who walked out was not making a statement about tax policy or healthcare. They were making a statement about the Constitution. They were refusing to lend their presence and their legitimacy to an event where the founding document was being publicly degraded. These are defensive actions by a branch of government that is under siege. It is the institutional equivalent of an immune system mobilizing to fight off a massive infection. But the terrifying truth is that the court possesses very little enforcement power. As Alexander Hamilton noted in Federalist 78, the judiciary has neither the purse nor the sword. It controls no army. It commands no budget. Its power rests entirely on the willingness of the other branches and the public to obey its rulings. If a president, backed by a substantial portion of the population, simply decides to ignore a Supreme Court decision, there is very little the court can physically do about it. The U.S. Marshals theoretically enforce federal court orders, but they answer to the executive branch. If the president orders them to stand down, the enforcement mechanism evaporates, and we are left with a paper victory and a constitutional vacuum. So where does this escalating confrontation lead us? The Supreme Court will eventually have to hand down rulings on these blockbuster cases about tariffs and immigration and emergency powers. Those rulings will either reaffirm the constitutional boundaries of the presidency or they will validate Trump's expansive vision of executive supremacy. Given Trump's behavior, it is almost impossible to imagine him graciously accepting a ruling that goes against him. He will do what he has done to Judge Boasberg. He will attack the justices personally. He will call them names. He will tell his supporters that the fix is in, that the deep state is strangling the will of the people. And then the real test will begin. Will the administration comply with a court order it does not like? If the court rules that a particular deportation policy is illegal, will the deportation flights stop or will they continue under some new, creatively crafted justification? If the court strikes down a tariff regime, will the Customs and Border Protection computers be reprogrammed to stop collecting the money, or will the administration simply slow walk the compliance until the ruling is effectively meaningless? We are heading into the kind of showdown that the framers dreaded, a direct collision between a president determined to wield maximum power and a judiciary trying desperately to hold him to account. Let us pull back and examine what this all means for the average American who is not steeped in constitutional law or glued to the daily drama of the courts. The foundational promise of the American system is that no single individual gets to be the king. The entire revolutionary project was a rejection of concentrated, unaccountable power. The checks and balances were designed to slow things down, to force deliberation, to prevent any one branch from steamrolling the others. That system only functions if the players accept that losing in court is part of the process. The president does not have to like every judicial decision. He is free to criticize the reasoning. He is free to file an appeal. But if he crosses the line from criticism into intimidation, if he starts treating judges as enemies to be destroyed rather than neutral arbiters to be respected, the system stops working. When the president says that his authority to protect the nation means courts must be ignored, he is, whether he fully realizes it or not, laying the intellectual groundwork for authoritarianism. The definition of a constitutional democracy is that the leader is subject to the same laws as everyone else. If the leader is above judicial review, if he can brush aside court orders with a wave of his hand and a fiery tweet, then the law is no longer the law. It is just a set of suggestions that apply only to people without power. The response from Trump's political base is a fascinating and deeply troubling window into how much the public's relationship with democratic norms has changed. His supporters see these attacks on judges not as a bug of his presidency, but as a feature. They voted for him precisely because they want him to tear down the existing system, which they see as hopelessly corrupt and biased against them. To them, Judge Boasberg is not a neutral arbiter of the law. He is an Obama-appointed political operative wearing a robe to disguise his partisanship. When Trump calls him a lunatic and demands his impeachment, the base cheers. They see it as a strong leader finally standing up to an unelected group that has been running the country behind the scenes for decades. There is a kernel of legitimate frustration embedded in this worldview. The federal judiciary has expanded its influence over policy dramatically. Judges do sometimes overreach. The judicial confirmation process is a broken, hyper-partisan nightmare, but the solution to judicial overreach cannot be the complete annihilation of judicial authority. That is not a cure. That is a bullet to the head of the patient. The proper response to a judge whose rulings you do not like is to win elections, confirm better judges, and argue your cases persuasively on appeal. The response cannot be to threaten the personal safety and job security of anyone who rules against you.